Welcome to INN's Student. INN Student is a platform for law students to come here and deliver a lecture on the topic of their choice. Today we have with us law student Vrushti Dedhia. She is going to speak on death penalty, a capital punishment. She is from KES Shri Jayanatilal H Patel College of Law. So without wasting further time, I would request her to commence with her lecture. Thank you.
Returning violence for violence multiplies violence, adding deeper darkness to a night already devoid of stars. With this proverb, I, Ms. Vrushti Dedhia, would like to introduce to my topic of death penalty, a capital punishment in India. Death penalty, also known as capital punishment, has been a subject, debate and controversy worldwide, and India is no exception. The practice of executing a convicted individual as a form of punishment for particularly heinous crimes has long been embedded in legal system, yet the ethics, efficacy and human rights implications of such a penalty continue to stir discussion. India, as a democratic and constitutionally secular nation, finds it grappling with the question of whether the death penalty should be retained, reformed or abolished altogether. Historical context of the death penalty in India. India has a rich history when it comes to the application of death penalty. Under British colonial rule, the death penalty was a prominent part of legal framework, with hanging being the most important method of execution. After India gained independence in 1947, the country retained the death penalty with its criminal justice. Primarily, the certain grave offences, the IPC, Indian Penal Code, drafted by British in 1960, allowed the death penalty in case of murder, treason and certain other serious crimes. Post-independence, Indian state were determined to maintain a balance between justice and humanitarian considerations. Over time, however, there were calls for reforms and change as the evolving social, political and legal landscapes demanded a review of the practice. The Constitution of India adopted in 1950 did not explicitly abolish the death penalty, but rather left the matter to be decided by the legislature. Recently, the Indian legislation have amended the whole of Indian Penal Code 1960 to Bharatiya Nyaya Sanhita 2023, which has changed only the numbers of the sections, the name of the act and certain provisions. Death penalty in different religions. According to Hindu law, in ancient and medieval periods retained a system of punishment that included death for specific crimes. The law emphasized retributive justice, wherein the severity of the punishment matched the gravity of the crime. According to Arthashastra, written by Kautilya, the chief advisor of Emperor Chandragupta Maurya, the death penalty was reserved for the gravest offences such as espionage, murder and high treason. The Arthashastra also provides that the rule had the authority to execute a wrongdoer in order to preserve the integrity and security of the state. During this period, there were also philosophical considerations. For the application of death penalty, the law allowed for the possibility of mitigation circumstances such as criminals' repentance of the potential for reform. Although Hindu law allowed capital punishment, it was not viewed solely as an act of revenge, but also as the means of correcting society. According to Islamic law in India, during the medieval period saw a shift in the legal framework with Sharia law being introduced to the Indian legal system. Sharia law, which is derived from the Quran and Hadith, including provisions of the capital punishment, particularly crimes considered in Qiyas and Hadith. Under Islamic law, capital punishment was reserved for specific crimes such as murder, theft, apostasy and rebellion. The Mughal emperor, which ruled much for India from 16th century to 19th century, followed these principles. However, the application of the death penalty varied significantly depending on the ruler's approach to justice. Mughal emperors like Akbar were known for the relatively lenient use of capital punishment, often preferring imprisonment or exile over execution. In contrast, rulers like Aurangzeb were more inclined to enforce strict punishments in line with Sharia law. Legal provisions for the death penalty are as follows. Under Bharatiya Nyaya Sanhita 2023 BNS, the death penalty can be imposed for the offences such as murder, section 103, particularly in case where the crime is committed with extreme cruelty, premeditation or in cold blood. Terrorism related offences under anti-terrorism law like Terrorist and Disruptive Laws Prevention Act and Unlawful Activities Act. Rape and murder. The crime for rape followed by murder is one of the most heinous offences punishable by death under certain circumstances. Treason, acts of disloyalty against the Indian state such as wagering war against India or supporting enemies to the state. One of the crimes that have been connected to death penalty is wagering war against India or attempting to do so. Wagering war against a country is a crime that is specifically defined under section 147 of BNS. Anyone who commits a wager against India may be sentenced to death. For example, the case of Kasab. Section 230 of BNS has been added to the list of crimes punishable by death. According to section 230 of BNS, fabricating evidence is punishable by death penalty if it is done to obtain a capital conviction for a crime. A person who commits such crime can face death penalty. Section 103 of BNS imposes death penalty for a person who commits murder. Assisting or supporting a minor's suicide has been associated with the death penalty under section 107 of BNS. At the age or 18 or an intellectual disabled person in committing suicide. As a result, anyone who commits this crime can face death penalty. Kidnapping or ransom or other purpose is a serious offence punishable by death. Kidnapping a person with the intent to cause them harm or death which is specified under section 140 subsection 1 of BNS. Any person involved in the commission of sati, directly or indirectly, is subject to the death penalty under the Commission of Sati Prevention Act 1987. Based on previous conventions, section 31A of the NDPS Act has introduced the death penalty for providing financial support or taking part in production of sale of narcotics or of psychoactive substance in predetermined amount, for example opium 10 kg or cocaine 500 grams, etc. For giving evidence that leads to the convention of execution of an innocent member of scheduled caste or scheduled tribe is punishable by death under the Scheduled Caste and Scheduled Tribes Act 1989. Various offences committed by members of the military forces under military laws may also be punishable by death. Also, there are few exceptions to Indian laws where minors, pregnant women and intellectually disabled persons are not offenders and are exempted from getting death penalty. Clemency powers. For the death sentence imposed by Sessions Court to become final, the sentence must be confirmed by the High Court. If the conviction is upheld, the condemned person may file an appeal with the Supreme Court. If the appeal petition is denied by the top court, the condemned person may then submit a mercy petition to the President of India and the Governor of the state. Despite the fact that clemency powers may be utilized for a variety of cases in a variety of contests, they also act as the last line of defense against the possibility of judicial error or a miscarriage of justice. This puts a heavy burden on those who exercise this power and necessitates careful considerations, close examination of court documents, and through investigations when deciding whether to grant clemency, particularly when petition comes from a prisoner who is about to put to death and has a confirmed death sentence from the court. One of the most important case related to clemency powers is Shatrughan Chauhan versus Union of India 2014, where the Supreme Court held that prolonged delays in deciding messy petitions could be valid ground for commuting a death sentence to life imprisonment. This ruling underscored the importance of humane treatment for death and now prisoners. For the certain case laws which says that death penalty should be given and certain others where the death penalty should not be given. Hyderabad veterinarian case. In Hyderabad veterinarian case 2019, the female doctor was all alone on the scooter which she parked to the Shamdabad Plaza and where she took the taxi to the office where she was going. In meanwhile, 4 accused were monitoring her and which led them to punch the scooter in her absence. When she came back from her work, she saw that the scooter was punched, and in meanwhile, the 4 accused came and started forcing her and burned her body. The case was clear-cut for awarding death sentence, but here the police encountered the accused, leading to questions about our Indian criminal justice system. Another case, Siddhartha Vashisht and Manu Sharma vs. State, NCT of Delhi 2010. Siddhartha Vashisht and Manu Sharma vs. State, NCT of Delhi 2010 was also known as Jessica Lal case. Was one of the horrifying death case which lead to society to know that sometimes money can buy anything but not the justice. In this case, the girl was shot to death when she refused to serve alcohol to one of the accused. Her sister had to run to all the courts for justice. Finally, through a media trial, she led to having the suo motu taken for the High Court. In this case, the accused manipulated the prime eyewitness to become a hostile witness, which led to the court to award him the punishment of life imprisonment. This judgment was passed after seeing the balance between aggravating and mitigating factors. Last but not the least, I would conclude as the death penalty remains one of the most contentious issue in the Indian society and law. While it is argued by some as necessary for justice and deterrence, others see it as a violation of fundamental human rights and an irreversible punishment fraught with potential for error. It is again a controversial topic where from one side we say that giving death penalty and applying strict law is good to reduce crimes, but in opposite of it, even violating fundamental rights of right to live is bad. In such cases, the victims are not given proper justice by the judicial system. The future of capital punishment in India rests on a delicate balance between protecting society, ensuring justice, and respecting human dignity. Here in India, laws are mostly made after the case is registered, whereas in other countries, laws are made to prevent the cases beforehand. India remains one of the few democracies that retain the death penalty, but there is an ongoing debate about its relevance and effectiveness. Advocates of abolition argue that the death penalty is inhuman and violates fundamental right to life. They also point to risk of wrongful convictions and lack of evidences that the death penalty serve as an effective deterrent to crime. On the other hand, supporters of the death penalty argue that it is necessary to tool for dealing with the most heinous crimes, especially in case involving terrorism, rape and murder. They believe that certain crimes are so egregious that only the death penalty can provide justice to the victims and their family. An eye for an eye and a tooth for a tooth. With this slogan, I would end my speech. Thank you.
Vrushti, thank you very much because you had touched a very nice topic, and I think a topic which is debated even today, not only in India but several other places, because this capital punishment is getting in conflict with the human rights. So it's a very dicey situation even for, I think, judges when they sign a capital punishment. Thank you very much. It was a nice overview of this particular act, and this is a small token from Hammurabi to you.